Hi everyone, my name's Aotearoa Delamere. I'm a General Manager for TDA Immigration and a Licensed Immigration Advisor. Today I'm going to interview my father Tuariki Delamere on a matter that we at TDA consider to be one of a monumental importance as it affects the privacy rights of all New Zealanders, citizens, residence holders, as well as those migrants holding work visas. Most of you are aware Tuariki Delamere was way back in the dark ages the Minister of Immigration, and he is well known for challenging Immigration New Zealand when he believes they have made and acted unlawfully or made decisions that are contrary to immigration instructions. And of course, he is well known for winning those challenges. Anyway, Dad, tell everyone what this issue is all about and how it's got you all worked up.
Yeah, hi everybody. Yeah, this issue has definitely got me worked up. In a letter of 13 June, Immigration New Zealand declined my client's work visa application. The ruling was that they said they have the right to require every employer in New Zealand to provide to Immigration New Zealand the personal details and private information, including all payroll records of every employee in the company, including New Zealand citizens. And with the new accredited employer regulations having come into force on 23 May 2022, I believe it's critical that this matter be resolved, because if this ruling is allowed to stand, then our privacy rights, as individuals in this country will be on a par with North Korea. We just won't have any privacy rights if Immigration New Zealand are allowed to demand the private payroll information of everyone in the country.
Well, that sounds pretty unbelievable. How did this come about?
Well, my client applied for an essential skills work visa in December 2021. And Immigration New Zealand demanded and required that the applicant and his employer provide the time and wage records, the holiday and leave records of all employees since 1 October 2021, and also to provide an organization chart of the company listing the names of every employee, their dates of birth, their job titles, their visa status, and their salary and pay rates. Now, I informed the employer and also informed Immigration New Zealand that it was my opinion that Immigration New Zealand was acting illegally, asking for that information, and the employer would be acting illegally if he provided that information.
Okay, so what happened?
Well, the employer didn't provide the requested information about the private details of his employees.
Then did INZ decline the application?
Yes, that was last Monday, 13 June. The decline letter stated that the reason for declining the application was because the employer did not provide the requested information. That is, the private records and information of every employee, including New Zealand citizens and New Zealand residence visa holders.
So what are you doing about it besides letting me interview you?
Well, on 14 June, I lodged a complaint with the Privacy Commissioner. That's last Tuesday, because I believe that Immigration New Zealand's decision has massive implications given the recent introduction of the accredited employer work visa instructions. I also sent a copy of my complaint to the new Minister of Immigration, the Honourable Michael Wood, and I also copied the Chief Executive of MB, the Ministry of Business, Innovation and Enterprise, given that they are the department that manages Immigration New Zealand.
And so you are claiming that what INZ did was unlawful. What do you think that? Why do you think that?
Well, I told Immigration New Zealand that their request breached the principles of the Privacy Act. And they wrote back claiming that their demand, their request, was mandated by Immigration Instruction W210.5C, which states that immigration officers may also request other evidence or confirmation of the employer's past and future compliance with employment and immigration law.
That instruction seems pretty clear, doesn't it?
Well, I've no problem with the instruction itself as long as the information requested is done so within the law. And in this case, I believe that request is not within the law. In my correspondence to Immigration New Zealand, I also pointed out to them that immigration instructions cannot be contrary to legislation. Legislation always trumps an immigration instruction. And I believe that their interpretation of instruction W210.5C is a breach of the principles of the Privacy Act.
And what did INZ say to that? Did they agree with you?
Well, Immigration New Zealand certainly didn't agree with me. Immigration New Zealand claimed that Section 11(1)(e) of the Privacy Act confirms their right to request the private information of every employee in the company, and confirmed they believe their right to demand that information from employers. And so let me quote from the Privacy Act, Section 11(1)(e), quote, "An agency that holds personal information must not disclose the information to any other agency or to any person unless the agency believes on reasonable grounds that the disclosure of the information is necessary to avoid prejudice to the maintenance of the law by any public sector agency, including prejudice to the prevention, detection, investigation, prosecution, and punishment of offences." End of quote.
So why do you think Immigration New Zealand is wrong in their interpretation of the Section 11?
I think that's, well, in my interpretation, that's quite easy. Section 11(1)(e) refers to the agency holding the information. And Immigration New Zealand is not the agency holding that information. It's the employer that holds that information. And in this case, the employer does not believe there are any grounds that his refusing to disclose the personal information of his employees, refusing to provide it to Immigration New Zealand, prejudices the maintenance of law and order in New Zealand in any way, shape or form. Let's say we have a migrant nurse who's been offered employment by the Auckland District Health Board to work at Auckland Hospital. And the Auckland DHB has over 11,000 employees. The Immigration New Zealand is claiming that they have the right to require the Auckland DHB to turn over the personal files and payroll files of all 11,000 plus employees. And can you imagine the outrage that would happen?
Well, it will certainly be fascinating to see how this plays out. Has Immigration New Zealand or the Minister of Immigration responded to your complaint?
Look, as yet, I've had no acknowledgement from the Minister or from the Chief Executive of Immigration New Zealand.
Why do you think the government has done this?
Well, you know, it's my best guess that actually Minister Wood is probably unaware of this unless they've shown him my letter. I mean, the way the Minister's office works, he doesn't get his emails himself. They're intercepted by a staff member, and immigration emails are then sent on to Immigration New Zealand in the first instance. Well, at least that's how it used to work, you know, 1,000 years ago when I was the minister. And so I just can't believe that the government has done this deliberately. I just think it's a misinterpretation down the chain in Immigration New Zealand.
Well, they certainly know about it now.
Well, true, let's hope so. And if I'm right, and the minister and the government, and I hope the minister and the government are equally shocked at what Immigration New Zealand claims is their right to have the payroll information, pretty well, of every New Zealander.
Have you heard back from the Privacy Commissioner?
Yeah, I have. They just contacted me just to let me know they received it, and they are assessing my complaint at the moment. If the government allows this ruling by Immigration New Zealand to stand, then this, as I said before, takes us down to the privacy rights that they have in North Korea. It means we don't have any. So it must be stopped.
Well, everyone, that concludes my interview with Tuariki Delamere. As shocking as his revelations are, let's hope that his complaint will see the government force Immigration New Zealand to back down and admit they were wrong. If any of you, be an employee or employer, and you feel that you have been wronged by Immigration New Zealand's decision, please feel free to contact us at TDA Immigration.